Howdy, howdy, folks. Do you want to know the truth? Do you want to hear the deep, dark secrets about the 7-year background check? I am not only going to discuss the secrets about the 7-year background check, but I will also let you know the stark differences between a 7-year background check and a 10-year background check. I get asked this question all the time. What exactly is a 7-year background check? And does it apply to the background checks I run? And at first glance, you may think those are fairly simple questions to answer, but the devil is in the details when it comes to background checks and what you can and cannot report. Let me be very clear about this one fact, folks. I am not an attorney, nor do I play one on TV or YouTube for that matter, and this video or any of my videos should never be considered as legal advice. This is just my opinion based on my experience as a professional private investigator. Every state, folks, as well, many municipalities have their own rules, regulations, and laws that apply to background checks, or should I say, what can be reported on background checks for specific purposes. It is incumbent upon you to ensure you know the rules, the regulations, and the laws that apply to your specific situation. On the federal level, there is this little thing called FCRA, or the Fair Credit Reporting Act, and this is what we will focus a lot of our attention on during this video. The FCRA, Fair Credit Reporting Act, was created way back in 1970 with the intent to protect consumers from unfair reporting on their credit backgrounds, which many times before FCRA allowed creditors to deny services and opportunities to individuals based on a wide spectrum of differing information. At one point, there was widespread abuse in the credit reporting industry that included requirements for investigators to meet quotas of negative information and data on subjects. And to meet those quotas, some investigators fabricated that negative information or included incomplete data on the background. And you wonder why PIs, private detectives, and private investigators had such a bad reputation back in the day. If you as a PI are doing background checks, and I know most of you are, listen very closely. If the intended use of the data found in that background check has anything to do with anything monetary or of other value to the subject, it very well may fall into the realm of FCRA requirements. Whenever you are doing a background check, you may very well be considered by law a consumer reporting agency, and the big secret here is that this designation is regardless of whether or not you call yourself a consumer reporting agency. Here are a few examples where the FCRA requirements apply if you are doing background checks for lenders, insurers, and employers. Just to name a few of the most common applications, your background checks, your background reports probably need to be FCRA compliant. So if you are doing tenant background checks for landlords, property owners, property managers, those types of entities, well, you must follow the FCRA. Or if you are doing anything employment related, this includes pre-employment, post-employment, and during employment backgrounds, yep, FCRA applies to you as well. But wait a minute, where does a 7-year background check come into play when it comes to FCRA? Let's look at criminal records first on background checks. According to the FCRA, the 7-year reporting rule for reporting criminal charges, the window starts when the charges are filed, not dismissed. Wait, what? Yep, employers, landlords, insurers, and all those other similar entities need to know that any criminal charges exceeding that 7-year window cannot be included in the background report. Not only can they not be included, but they cannot be considered when making decisions about the individual. So you as a PI doing these type of background checks need to understand the FCRA prohibits background screening firms, which is you by the way, from reporting any arrest record or adverse non-conviction information older than 7 years. And listen up closely, that applies to convictions as well. According to FCRA regulations, the only adverse information credit reporting agencies, just like you, are allowed to report on background checks are convictions that occurred within the last 7 years. Here are the main restrictions FCRA includes on background reports. You cannot provide any information on any arrests that are more than 7 years earlier than the date of the report. As well, you cannot report any personal medical data without a consent form. So if you find out medical information about the subject of your background doing, let's say, an OSINT investigation, you cannot report that information unless the client has a medical data consent form signed by the individual. Now, when it comes to employment backgrounds for positions where the person earns over $75,000 annually, then those backgrounds can include arrest information longer than 7 years in the past due to a salary exception. But there are time limits that still apply for that scenario, and we will get to that in just a moment. The FCRA, or the Fair Credit Reporting Act, requires that all CRAs, credit reporting agencies, which by the way includes you if you are doing background checks that fall within the rules of FCRA, to follow specific guidelines. Those guidelines include these steps. First is the notification process. The applicant must be notified conspicuously in writing on a separate form that a background check is going to be conducted on them. This is commonly known as the background authorization form. The individual must be informed of their rights too. All applicants must be advised of their rights under the FCRA. This is called the Summary of Rights Notification, which is also on a separate form. Then there is the AAN, or Adverse Action Notification. The applicant must be notified should the background check uncover derogatory information that might exclude the applicant from further consideration. This is known as adverse action. The final thing is the dispute stage, where the applicant has a right to dispute any derogatory information, which requires the CRA to re-investigate the information. The most common area of dispute for FCRA compliant required background checks are regarding criminal convictions or arrests that are outside of the scope of the FCRA. In other words, are past that 7-year window of reporting eligibility. In fact, here is another huge secret. This one, folks, can save you and your business from some major setbacks if you are doing employment, housing, and other FCRA required backgrounds. Just like there is a ton of information on the internet to help you become a better PI, like the PI Guy YouTube channel, there is also a plethora of information out there for bad guys to figure out ways to scam the system and get rich quick. One of those biggest scams out there is for bad guys to apply for jobs or housing at places where they believe the employer or landlords will use people like PIs who are not aware of the requirements. Then when they are turned down as an applicant and they inquire as to why, they are told something came up on the background. They start the inquiry phase requesting the background reports, and if they find that old data in the report, boom, the lawsuit has begun. So you, as a PI, as a credit reporting agency, need to know what and when these things can be reported. So we better move along quickly onto the 10-year rule, then the biggest, deepest, darkest secret of 7-year background checks that most people do not know. There is a 10-year background report that is much like the 7-year background check report. Remember when we said if the subject of the background makes over $75,000 a year, the time may be extended? Well, that is one of those times when the 10-year rule applies. Now, the difference between the 10-year and the 7-year rule is quite simple, folks. It is 3 years, that is all. Everything else is still the same, but now you can report if the subject earns over $75,000 annually, criminal arrests and convictions up to 10 years old. But wait a second, it is not quite that simple. I know. It seems to start to make sense, then we get thrown another curveball. We covered this briefly at the beginning of the video. Almost every state today, as well, many municipalities have their own rules, regulations, and laws that apply to what can be reported on background checks. Some states have their own 7-year rule, which has its own set of limits. California, for instance, further limits the 10-year rule to the subject making over $125,000 annually. And some states like Alaska, California, Indiana, Massachusetts, Michigan, and New York, just to name a few, do not allow for the reporting of any non-conviction data. So even if the subject you were doing the background on was arrested yesterday, you cannot report it on a FCRA compliant background check, as that is considered non-conviction data or information. Then there is all the other data involved in the background check report. As a policy, we apply the 7-year rule to all of our FCRA compliant backgrounds, so we do not go back past 7 years on address history, phone history, bankruptcies, judgments, civil litigations, or anything else for that matter. We also require the client to provide us with the applicant's full application to include all waivers and notification forms. If they are missing them, we will not do the background until they can provide one. I know you may have second thoughts now about doing background checks and background reports, but now you know some of the mistakes to avoid while doing them, and I made this video for you to help you avoid other common PI mistakes.